Welcome to the Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program has been created to educate, inform, and help you with law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. We continue to provide information and resources that will help you decide whether or not you need to contact a lawyer. Perhaps will help you to determine that you can handle some issues yourself. If you decide to connect with an outside professional counsel, lawyer, you'll be better prepared and hopefully achieve the best possible results. Our goal, of course, is to save you time and money in achieving those best possible results. We continue to thank the Bazar and Associates law firm in East Providence who help us with the issues that we tackle every week. David?
Hi, thank you.
Thank you for joining us. So, we've talked about tenants and landlords before. So disputes between tenants and landlords, they can take different forms. We've spoken about upkeep and repair issues, non-payment, even potential evictions. So how do you best navigate through those issues, taking care of making sure you uphold your side of the bargain and at the same time dealing with it to the full extent of the law? So today we look at the rights and responsibilities, the rights and the wrongs. So legal issues. You always say it starts with write it down. Let's start with a contract. What should be in it? Let's do a primer on that first.
All right. So, and of course, there's differences between residential and commercial.
Let's start with residential first.
All right. So the terms that are most important in a residential contract for the tenant are the length of the lease and the amount that you're going to pay. Then the other issues that come up is who's responsible for snow removal, maintenance, that type of thing. Usually, the landlord is responsible for maintenance of most things. The snow removal can be negotiated in a lease, but if it's more than a single-family house, usually it's, again, the landlord's responsibility. Security deposit, that's usually in the lease and what the amount is, and there are terms that override the lease in terms of what the legal rights and obligations of each party is with a security deposit, but it's best to have it laid out in the lease. So from the tenant side, those are some of the more important issues. From the landlord side, those are important issues, but in addition to those issues would be whether or not the tenant is allowed to bring somebody else in to live in the apartment or not. Do they have to get your permission? Is it going to change the amount of the rent? Can they have pets? What are the responsibilities with the pets? What is the responsibilities on moving out besides the normal things? Are there any other things that you might want to put in there? So there are a lot of different terms that could go into the lease. Those are some of the most important ones.
So you had a pretty lengthy list there that you rattled off quite quickly. And it seems that, as we always say, we want to provide resources. So the resources, some people can do it online. That would be findlaw.com and nolo.com that give you some overview or checklist of things that you could, should, and might include, whether you're the landlord preparing it or the tenant about to sign a lease, or what's the difference between a lease and the rental agreement?
Well, I think that two different terms that sort of say the same thing, unless the rental agreement doesn't really give you a term, but just it's a month-to-month lease with some terms of what you have to do or not do by agreement. Usually a lease has a set term to it, maybe with an option period or something.
So interestingly enough, in preparing for this again and refreshing my memory on some of these things, it was very interesting to see that while there's a checklist of basic things to cover, there are so many things that can come back and bite either one, so to speak, for not having included it or not having spelled this out. So some people have a home business. It certainly makes sense that if you were moving into someone's house or apartment or whatever, that you need to, the landlord, have to specify whether or not you would allow that, or the zoning allows that?
It really becomes a zoning issue, and usually some boilerplate language that might come into play on that is that you don't use the property for anything that isn't properly zoned for use in that area. So some cities and towns have ordinances or zoning rules as to what you can do in your home, what constitutes a home business that's allowable and what isn't. deliveries, for example. Can you have deliveries? Well, if a house can have deliveries, perhaps a home business can. But what if it's deliveries every day? Depends what the actual wording of the ordinance is. If you're having employees come in, if you're running a landscaping business and they're coming to your house to get all the equipment that you stored there and starting it up, that may violate a home business ordinance, whereas if you're selling things over the internet, for example, and really don't have anybody come into the home, it probably doesn't violate the language of the ordinance.
Interestingly enough, it certainly is worthwhile to check whatever your state codes are, but while we're not in California, wasn't it interesting to find that in California, you're not supposed to be running a daycare center out of your condo, for example. However, if the tenant moves in and as a sublessee, if they have a license to run a daycare center, they actually can do that, even though it's not supposed to be legal in that state. Certainly that's getting in the weeds, but it if nothing else, explains that there's really very good value in having someone take a look at what you're preparing to propose for your lease.
Well, and that would be unusual in most states that a tenant could have more access or use of a piece of property than the owner.
Exactly, good point.
I don't know of anything in Rhode Island or Massachusetts where that would also be the case. But you don't want, as the landlord, your tenant doing things that aren't allowed that gets you as the owner in trouble. So if you lease a piece of property to a tenant who's supposed to use it as a residential piece of property and they're running a business, it's a good idea to have it in your lease that they won't do anything that would violate a zoning ordinance, because the repercussions will initially come back to the owner of the property.
Yes, later on I want to review. That ends up topping one of the lists of the most frequently frequent causes of disputes. Oh, that'll be an interesting thing to talk about. We talked about making repairs. So it makes sense that if you're the property owner, you should be taking care of repairs. Yet, if you're preparing a lease, do you need to spell that out? I assume that if I'm a landlord, I don't have to change every light bulb.
Right. So now, again, residential versus commercial is going to make quite a bit of difference, because when you get into the commercial, and we didn't really talk about commercial leases, and we can go back later, but you could have a triple net lease with a commercial lease, which really basically means the tenant is responsible for all the expenses, and you lay out all the responsibilities that they have, and taxes and insurance and whatever other expenses may float to the property go to the tenant. Whereas in residential, we very rarely would ever see a lease like that. Generally speaking, it's you pay for the use of the apartment. The landlord's responsible for everything that goes on outside of it. Perhaps there's some responsibility for even some things inside, usually spelled out, but more likely than not, as you say, light bulbs and things of that type of thing, the tenant's going to be responsible for. The roof leaking into the apartment is going to usually be the landlord's responsibility, and that's going to be spelled out. And that does bring you to another interesting area, one that actually I've been dealing with for a client most recently, where she and two roommates rented a 3-bedroom apartment, and the leak was into her bedroom. And so she was displaced from her bedroom, and it took the landlord forever. And it was a commercial landlord. They own many, many properties, and it's a large apartment building, forever to get in and to fix it. So she was out of her apartment, so she wrote to them quite appropriately, I'd like to be compensated for the time lost from being able to stay in my apartment. And they wrote her back and said, well, it wasn't due to our negligence, and you weren't displaced from the apartment, just your bedroom, so we're not responsible. So I wrote them back and I said, well, in fact, it was due to your negligence or malfeasance that she was out of her bedroom for as long as she was displaced actually from the apartment, because she couldn't stay in the apartment with her roommates. They didn't want someone bunking in their bedroom, and nor should they have had to have that done. And they rented an apartment that had a certain amount of square footage, and some of it became unusable. And if it wasn't initially due to the negligence or malfeasance of the landlord, actually the property manager, it certainly became their responsibility when it took them 18 days to fix it. So we're still going back and forth on that, and that may end up in suit. So then the next question is, can or can she not withhold rent given that situation?
Can she?
Well, you know, it depends state by state. Where she lives, and it's not Rhode Island, it's not Mass either, so I'm working with an attorney, it's in New York. The recommendation is pay the rent and sue to get it back. They may be allowed to, but then it comes into issues of renewal of the lease, if it wants to be renewed, and all sorts of other things. So the attorneys in New York recommendation is just have her pay it, we'll sue and get it back. Many other states, we would pay it into escrow and say, here, we have your money, it's here. Since they did fix it finally, there's also a question in New York as to, now it's not an ongoing problem, so can you withhold it in order to get them to fix it since it's already been fixed? You're entitled to some abatement and some compensation, but their advice to us and what we're following is pay it and sue to get it back.
And suppose there's something wrong with the roof, it's the middle of winter, it's icy, roof repair can't, or replacement can't be done. That means it's taking another 2 months. Either she's inconvenienced and lives in the other room, or she moves out. Now you're talking compensation, I would think, or some restitution that needs to be made.
Yeah, and if that were the case, maybe we have a different, slightly different situation. But this was a repair that they could have come in immediately and done, so they don't have that to fall back on. But I think in general, if you have a situation where the property becomes unusable, then there is, and these are terms that can be put into a lease, there is compensation to be had. And the landlord in that other case said, contact your renter's insurance and make a claim. Well, really, no, it's your negligence that caused this.
Good point.
Not any reason for that to have to be done. But if you now have a situation where they don't have control, and you don't have control, and you can't use the property, then there should be a combination of rent abatement and renter's insurance or some other form, would be renter's insurance, to provide for some coverage for you to go somewhere else, compensation to be able to do that.
Let's work on that a little bit more. So in a contract, suppose she didn't pay and then didn't pay, it was a second month and a third month because there's ice on the roof, say. Should she or should the landlord at the outset of a contract include what happens if the rent isn't paid for whatever reason? I don't feel like paying, I can't pay, or I'm withholding it. Apparently, some can put a lien on your some landlords can put a lien on your personal property. Should someone allow that to be in a contract, or should that just not be allowed, David?
Well, as a tenant, you don't want that. As a landlord, you would.
Yes, so?
Most personal property that someone is just bringing into an apartment wouldn't cover a month's worth of rent anyway. So it depends, again, on the situation. Now, in commercial situations, that could be very different because you might be renting to a manufacturer who has big equipment with a lot of value. And so that's, again, commercial, residential, totally different situations. But most residential situations, the tenant doesn't want to lien on their property, and the landlord doesn't gain much by getting it in most instances.
They won't, so they don't need to worry about that.
Usually it's not in a residential lease.
Potential for eviction. So it's a terrible thing to think about being evicted. Someone forecloses on the landlord's property, you are automatically evicted, or are you?
No, not automatically.
How does that work?
So what happens is the lender who's foreclosing steps into the shoes of the original landlord when they do foreclose and the property becomes theirs. And so you are entitled to be treated just as you would be with the original landlord. It's, to me, more equivalent to if the landlord sold it to somebody else. So if you have a lease.
If you have a lease?
Yeah, if you have a lease and somebody buys the property and you're instructed by the original landlord to pay the new landlord, then you can follow that assignment and do that. The lease gets assigned to the new landlord. But the new landlord can't come in and say, I'm just going to ignore this lease and have you leave. You have rights. And that's what part of the reason of having a lease is for.
And if you can't break that lease, if you're the new landlord, the new owner of the property, does that go back to what should be in a lease in the first place, such as under what circumstances can, should, or might someone leave? How many days after the lease, or how much notice before the lease is up? I've read that apparently you should not even be discussing with your landlord what the next lease will be, because he may, if he's thinking about either terminating your lease or selling the property, there could be an implied understanding that you're going to continue it when in fact he doesn't. It gets very murky. So how does that play out, David?
If their lease ends and nothing has been done to change the lease and you pay on a monthly basis, you become a month-to-month tenant with the same rights and obligations of any other month-to-month tenant, which means that if you pay your rent monthly, then you're not going to get evicted. Now, can the landlord change the amount of the rent? There's a process for doing that, but they have to follow the process. It's not like it's a lease where it says year 1 is X, year 2 is Y, and it automatically becomes that. They have to give you notice and a proper amount of notice, and all of those rules are followed. And they have to evict you according to the eviction, if they do want you out, that they would have to follow with any other month-to-month tenant, which would require notice in advance and then the filing of an eviction, which would not be what we in Rhode Island would call a 7-day eviction, which is for non-payment of rent, but rather would be what we might call a 20-day eviction, because you have 20 days to answer it and file and discovery, and those can drag on for a while.
Apparently there are several circumstances under which you may be asked to leave, evicted. You did something terrible. You smoked in the apartment. Is that a reason? You didn't pay your rent? And then there are options. You pay the rent, you're not evicted. What are those three? There are 3 or 4 different options, I guess. With that.
And now again, residential.
Residential, for the moment.
If you have a lease or you're month-to-month, either way, you have to pay the rent when it's due. Then there's a little bit of a leeway period of about 14 days. If you become more than 14 days behind, then notice can be sent to say you're behind, you have to cure the defect, which is the payment of the rent. You haven't done that, then an eviction can be filed, you get to court. If you come to court and it's the first time, you can bring the money to court and cure the defect, and the eviction is stopped. But you can't keep doing that repeatedly. So there is, for a non-payment, an ability to cure the defect even after the eviction the first time is filed. Some of the other ones that you mentioned would be violations of leases. So most leases will tell you in the lease what the landlord has to do and what you have to do. So, for example, let's use your smoking, and it says in there there's no smoking in there, and you're given notice that you can't do that and you can continue to do that. The landlord can evict you for that. You have pets, perhaps, and they're not allowed. You can be sent a notice. You have a certain amount of time to cure that defect, remove the pet. You don't do it, the landlord can file an eviction for that. And then there is the month-to-month tenant who they want to remove. They have to terminate your tenancy. So they have to send a letter to you saying, we're terminating your tenancy. They have to give you enough notice, which is reflected by the amount of time. In other words, if you're month-to-month, it's 30 days. If you're week-to-week, whatever the amount of frequency of your payment is, that determines the notice that you have to get. And they can terminate your tenancy, but then you're evicted just like the other evictions that aren't for non-payment of rent.
With these issues that you described, so you see that your tenant has a pet or sublet it, or now has 14 more people in there than they were supposed to have in there. They fix it, or they dispute it. How do you go about disputing, I didn't really have a pet in there, well, that you saw it or you didn't see it, you took a picture of the pet when he was outside, or maybe you can't prove it. What are the steps if you are the tenant and you want to dispute your landlord who's saying, I think it's time, you better leave?
So you get the letter first to cure the defect. And you write back and you say, thank you for your letter. I do not have a pet. If there was a pet here temporarily, it was my mother visiting for the day. Sorry, I'll tell her not to bring her dog again next time, but we don't have a pet here. And then it becomes a matter of proof, just like any other case. If the landlord can prove that what you're saying is inaccurate, then they might win. But if they can't prove that, they'll lose.
Do you, as the landlord, have to put it in writing, or can you just call? butt holes up in court if
Yeah,
it ever
no,
comes
if
to
it's
it.
a lease, you have to follow the terms of the lease. I would argue most leases should have language in there that require written notice.
And then if you have, as the tenant, an opportunity to respond, again, you too must respond in writing. Should that be in the lease?
It should be in the lease, but it's always my advice, best practice, have it in writing so that you can show exactly the communication that you had with the landlord or the landlord with the tenant to the court if it becomes necessary.
So does it go to court, or is that something where we really don't need a lawyer? Maybe do we need a mediator? How does that play out? Is it a small claims thing? It's not a small claims thing unless there's money involved, and now we're talking about pets. So how does that get resolved? How
Well,
should it get resolved?
If it's an eviction and the landlord is saying, no, you're violating the terms of our lease, you can't do that, it has to get filed in district court in Rhode Island. And there is a mediation process possible in district court cases, but it's not necessarily required depending on the type of case that it is.
Yes.
And if we're looking at a situation, it's not small claims, so if we're looking at a situation where the landlord wants you evicted, you can negotiate that, yes, I am violating the lease, I do have a dog, but give me 3 months to find a place to go. A lot of times, different types of negotiations of those nature take place.
And again, you'd say that that needs to be in writing also.
Well, since it's in court, the court
It would
has
have
to
to
enter
be.
an order. And so it will be in writing because all orders for courts are in writing.
So let's talk a little bit about the commercial side of things, David. Yes, we understand there should be a lease. How are things most, where do you see the greatest differences between the commercial and residential?
So the greatest differences are going to be in, again, some of the expenses area. You have a commercial piece of property. Generally speaking, if we're talking about a building that is a standalone building with one tenant, they're usually going to spell out who's going to be responsible for snow removal, trash removal, what type of activities can take place in the building. Insurance is a very big one in commercial leases. Is the tenant responsible for insurance, and do they have to name the landlord as an additional insured on their insurance, or do they pay the landlord on a triple net lease to provide insurance? So these terms are much more detailed and significant than you would ever see in a residential lease. And it can also apply to a commercial lease in a strip mall or something of that nature, where there's a supermarket that's renting a piece, and there's a Dunkin' Donuts, and there's some other stores. Is each store responsible for the removal of snow from the parking lot, or is the tenant in front of each store, is the landlord responsible? And now we get into commercial snow removal people, and does the lease require you as the tenant to have a commercial snow removal person who also names both the tenant and the landlord as insured on their insurance policies? So there's a lot of detail like that.
So while the nolo.com and findlaw.com are available, those would seem to be more likely for the residential. Sounds like there's more nuances that you might want to have covered in a commercial lease, as in get a lawyer to make sure
Yeah.
there's another set of eyeballs on it.
Yeah, because now we can even talk about financial situations. Does the tenant have to, in the lease, sign a subordination agreement of the lease, perhaps, if the landlord is going to refinance and they have recorded the lease on the evidence of land records? Is there a non-disturbance clause in there about different things? So I would be hard-pressed unless it's a commercial tenant who's done many, many of these to think that they were going to negotiate and do the terms of a lease with a commercial landlord on their own.
If you have an industrial plant and you're the landlord, you have 5 tenants, and you say each of you will be paying partial utilities. I'm going to take the $100 and divide it by 5. You all owe 20. Well, depending on who you are as the tenant, maybe you don't use $20, you use 10, and would it make sense that someone then needs to say, you need to have separate meters on all of these things, and I need to make sure that they're all working properly, assuming that they'll work properly,
Yep.
But those kinds of things need to be dealt with as well.
And negotiated up front, because usually that's part of the term of the lease. And if you sign the lease, that's the lease. So if you have a concern that you don't use, and a lot of times what they'll do in a commercial piece of property is they'll prorate it based on the square footage that you use. But you may say, hey, the guy next to me is a restaurant with heavy industrial equipment that uses much more utility than I'm
Water
ever
or
going to
electricity.
use.
Sure.
So square footage isn't the way I want. But you have to negotiate that, and it has to be done up front.
And in the documentation process that you always say is so important, whether you're talking residential or commercial, apparently there's very good reason for the tenant and landlord in each case to do a walkthrough once they're going to sign, to check all of the nooks and crannies, to make sure that the things that should be working are working, or that the garbage disposal works in the home, and the, I don't know, something else works properly in the commercial setting too.
Yeah, well,
Take pictures of it, as they say.
yeah, so again, you're right. And on the commercial side, usually you're not renting a finished product, or sometimes you are, but if you're not, who's responsible for what build out, what can you do within the confines of the building? Do you need permission from the landlord to do that? This is all the beginning of the lease kind of negotiations and stuff. Is the landlord going to contribute to the cost of the build up? On the residential side, it's, is my stove working? Does the refrigerator work? Does the garbage disposal work? Are there holes in the wall? Take pictures, identify everything that's an issue before you move in. If it's not fixed, make sure the landlord knows that, and that you're not responsible on the way out.
Suppose you have complainers as tenants, whether residential or commercial. Theoretically, no landlord is supposed to retaliate against the said tenant, no matter how much they complain. Apparently, that is often used as a reason to raise the rent, and they say they're not really retaliating. How could you actually know that? What could you actually do about it if it happens?
Yeah, well, those are, again, difficult situations with the proof. If you have somebody who's a residential tenant and there's no lease and they're month to month and they complain about this and they complain about that, and then you get a large rent increase notice. I mean, are they entitled to increase the rent? Probably. Is it unreasonable? I mean, is that something you could take to court to try to figure out with a judge? That's a tough one.
So how do you actually document? We don't have time to discuss that now, but it seems like that might be something you want to be aware of, because you might find that a landlord is not dealing with you appropriately.
And so again, I like to keep things in writing.
Sounds like a good idea. We hope that these topics have been helpful to you. We hope that you don't have problems either as landlord or as tenant. We thank you for tuning in to Law Matters, because of course the law matters to you.